Anyhow, once I knew that things were being recorded, I would then state for the record, "Sir, would it be all right with you if I entered this room and engaged in these proceedings with a full reservation of my unalienable rights?" Now, of course, the judge is probably going to be silent in response to that, but you need to get that silence on the record. For and on the record, as there is no objection from the court, I will now be entering these proceedings and engaging in them under my own terms and conditions and with a full reservation of my unalienable rights. Are there any objections? Of course, there won't be any objections, because how could they deny you your rights? That would be silly. After all, who has the right to deny you your rights? We're all born equal, are we not? Or perhaps the judge was born a little more equal than you were. You tell me. Now, once you've established that you're in that courtroom, under your own steam and under your own terms and conditions, you may approach the table, and the judge will try his little tricks again, and he'll say, "That's where the defendant sits." Every opportunity, every offer he makes to you, I would say, "Sir," everything a question, of course, because if you remember from my previous broadcast, the master asks the questions, and the servant answers them. "Sir, would it be all right with you if I sat where the defendant sits, whilst reserving all of my rights?" At no point will you get an objection to that, because they know they cannot deny you your rights. And you only have the rights you know how to claim, so you're going to spend the whole case claiming your rights. You'll only be in there for 5 or 10 minutes, no doubt, but you're going to spend those 10 minutes in a very highly pitched game of mental chess between you and the judge, who can outwit each other, unless the judge is a very nice bloke. Before you start the conversation regarding the issue at hand, you will need to put the judge on his oath. Now, effectively, that means you're neutralizing him. He cannot practice law from behind the bench. And how do we do that? I would ask the judge, "Sir, do you have an oath of office?" And the judge might say something like,
What? Wait, no. I mean, yes. I mean, I signed something at some point. I think I have an oath on a piece of paper somewhere. No. Yes, I do. No. Is it? No, it's not here with me today. Yes, it is. I don't know. I've no idea. Yes, I have. No, I haven't.
You'll get all of that. And you're going to have those conversations. You're going to be wriggling, and they're going to be wriggling, and so on and so forth. But then the next question, of course, is, "Sir, if you don't have an oath of office, how am I to know that you are a judge or not?" If he says he doesn't have an oath, then I might ask, "Sir, with all due respect, am I to understand that you're impersonating a judge? Am I to understand that you won't qualify your oath and that you're impersonating an official? Sir, if you don't have an oath of office, you have no authority to be sitting there, and you need to step down. Am I wrong?" Ultimately, your final statement will be, "For and on the record, this court takes judicial notice of the judge's oath." Now, once you've said that, if the judge tries to practice law from behind the bench or tries to make any legal determinations, you're going to have him. You're going to have him good. The judge can only really mediate. He cannot get involved in any way, shape, or form. If he does, you have it on the record that he has been operating ultra vires, outside the scope of his office, outside the scope of his powers. So that's key. Sir, you have the judge neutralized. He's sitting there on the court as the referee, and that's just between you and the solicitor representing the plaintiff. So regarding the name issue, the judge is going to try to get you under his jurisdiction. He's going to try to create joinder between you and the legal fiction as many times as he possibly can, and he'll do that in many, many devious ways during the conversation. He might say,
"Now look, don't be a silly bugger. Are you or are you not Mr. Anti-Terrorist?"
"I am here as a trustee of a private trust of which Mr. Anti-Terrorist and the public are beneficiaries. Does anyone have any objections to me appearing as such?"
"Who are you?"
"I am who I say I am, sir. Who are you?"
How very dare you? I am Magistrate Jones, don't you know?
"Is that your given name, sir? Were you christened Magistrate Jones, or is that just some sort of legal fiction appellation?"
"Is this your name on my piece of paper or not?"
"Oh, well, if you let me see it, I can tell you, sir." "Oh, no. I'm not that person, sir. However, I am the agent for the name of the corporation on that piece of paper. How can I assist the court in that capacity?
Please, Mr. Anti-Terrorist.
Sir, with the greatest of respect, you keep calling me Mr. Anti-Terrorist. Now, is it not true that the title Mr. is only attributed to fictions? For and on the record, sir. Is that not true?
Look, I'm just calling you Mister because I'm being polite. It's the polite thing to do, don't you know? Weren't you taught that when you were young? Doesn't your family have any manners? We call each other Mister. It's the polite thing to do.
As I have previously stated, I am commonly known as Timothy, and I do not like to be called Mister, so you are dishonoring me in doing so. Would you mind, from now on, referring to me as Timothy during these proceedings? I would be very grateful to you, sir. Would you be so kind as to do that?
Please state your name for the record.
Sir, I am the authorized representative for that person with a full power of attorney. Is that not clear in my paperwork, sir? Would you like more time to look through my paperwork? Would that help the court?
Mr. Anti-Terrorist, do you mind?
By asserting that I am that legal fiction on that piece of paper, sir, are you suggesting that I'm public property?
Are you ready to proceed, Mr. Anti-Terrorist?
By calling me Mister, it would appear that you are operating under the presumption that I am an egregious UK person. Just what are the assumptions here? Are you assuming that I'm consenting to these proceedings? Are you assuming that I have elected to submit to the jurisdiction? Is that your assumption, for and on the record, sir?
Are you ready to proceed or not, Mr. Anti-Terrorist?
Do you have a contract where I have confessed to being a UK subject? Is that where you want to go? Attempt to coerce me into a contract? It is my understanding that you cannot lawfully proceed if I do not consent, and that you cannot lawfully make me consent. Is that not correct? Yes or no? For the record, sir. What if he says,
Now you listen here. You don't have that right in my court.
Really? Sir, do you have a private court? Then you have no authority to hear this. I'm guaranteed rights. I'm guaranteed to be heard in this court, sir. Is it not true that you should step down? Of course I wouldn't be that belligerent. I am exaggerating for effect, but you get my point. They will try to do that at every opportunity, and you need to be able to deal with it. Now, a little trick that I like to use when dealing with my own cases in court, which puts a stop to any of that Mr. Defendant monkey business, is I'll take my birth certificate in there. And if the judge starts the mistering, or if he starts the defendanting, I will take my birth certificate out of my folder, and I'll say, Sir, just to avoid any confusion, would you mind if I place the defendant here on the table in front of you so that I know who you're addressing at any point in this conversation? Now, the judge doesn't like that very much. In fact, a couple of my friends have been thrown out of court for doing that, which just goes to show that there is a major, major issue with that particular piece of paper. But that's what I will do. And in some cases, judges can handle it, in some cases they can't, because they know that the person that they are referring to is the person that is associated with the bond that is sitting in front of them on that table. Now, there are several things you need to keep in place whilst you are operating in that courtroom, and I'm going to make a few suggestions here. Now, the first thing you need to do is to calm down, really. This is going to be a very intense 10 minutes, 15 minutes, or whatever it might be. And you need to preserve your energy. Make sure that you're in a state of mind that you can cope with the pressure. So just suppress the need to rush. Don't babble. You will really shoot yourself in the foot. Take a deep breath before you speak. Speak slowly and clearly. Slow down. You need to display a peaceful confidence. You just stand there, stand your ground, as a man on the land, in a private business venue, doing business. That's all it is. It's just business. Don't repeat yourself. Ask a question, leave a little time for an answer, and if they refuse to answer, get their silence on the record. Don't argue or testify. You'll play right into their hands and invite a contempt charge. Don't say no, or but, or explain or justify. When you testify, you're participating in an appearance. You're confessing to your status as a debtor, as a defendant. Don't be aggressive.
What are you doing? Step back! Get away from me!
Don't start shouting at the judge and having him get all upset and leave the room. You're not going to get your remedy that way. Don't use language they don't understand. There's a lot of this language going around the freedom movement at the moment and the patriot movement. These judges have no clue what you're talking about. Make your conversation accessible and understandable for the judge in the court so that he can provide you with the remedy that you need.